United States District Court for the District of Columbia opinion in RNC versus Nancy Pelosi, rendered by Judge Tim Kelly, rejecting, obliterating, and demolishing every argument that we heard from Mr. Perry and Mr. Biggs. Their whole argument seems to be that Republicans were entitled to blow off subpoenas of the United States Congress that came from the January 6th committee because they didn't like the committee, they didn't think it was legitimate, they thought it was not validly authorized. The courts roundly and uniformly rejected those arguments. So now they purport to render the law for themselves. If they don't want to comply with the subpoena, they won't, and yet they would now hold other witnesses like Hunter Biden to a standard they won't accept for themselves. That's a remarkable thing. I started off this hearing, Mr. Chairman, by saying we believe that everybody should respond in good faith to the subpoenas of the United States Congress. Now, Mr. Biden asserts that he responded in good faith to what you repeatedly publicly asked him to do. And he's at least got an arguable, colorable claim that that's true. All the case law I've been able to read, Mr. Chairman, suggests that the committee is supposed to engage in good faith negotiation with witnesses, which is precisely what the January 6th committee did. The dates don't always work out. The times don't always work out. Some people want to assert a privilege. Some people don't. There are certain questions that are agreed to or not. So there are negotiations. But as I read at the beginning of this
hearing—
Will
the gentleman take a question?
But I will as soon as I get to that.
Excuse me, it's my time.
Oh.
Mr. Raskin.
Thank you, Mr. Conley. Why is the committee not engaged in that negotiation with Hunter Biden? I just don't understand that. I mean, he's a guy who appears to be 99% willing to do what you even asked him to do in the written subpoena, but he's given 100% good faith compliance with what you repeatedly publicly challenged him to do. So I don't understand why you won't meet with them and work it out, which is what every court in the land has said. The courts don't want to be involved in all this stuff, especially when you've got a guy like him who's overwhelmingly complying with what you're asking for, unlike all of these colleagues on the other side of the aisle who unfortunately 100% defied the subpoenas of the United States Congress, which is what they did. And I don't think those people should be able to vote on any subpoena relating to any witness in this committee until they render cooperation with the January 6th committee and come forth and tell us what they know. Now, there's another point that I need to make, and I want to thank Mr. Connolly for his indulgence here. Our good friend, the gentlelady from Georgia, referred to the murder of Ashley Babbitt. Well, the Department of Justice, the United States Attorney, and the U.S. Capitol Police Inspector General all rejected the idea that there was any
Point
murder.
of order, Mr. Chairman. Or inquiry.
There's no such thing.
There's never been a court hearing.
Mr. Chairman, we agreed.
Michael Byrd was never charged.
Reclaiming order here. The time is Mr. Connolly's. I yield back to Mr. Connolly.
Thank you, Mr. Chairman.
But I will submit for the record a document entitled Department of Justice Closes Investigation into the Death of Ashley Babbitt. United States Capitol Police document USCP completes internal investigation into the January 6th officer-involved shooting. I think it was a scandal. It was a tragedy that people died because Donald Trump put them at risk, as many of the former insurrectionists are now willing to say publicly, that he said you got to go and you got to fight and fight like hell, or you will not have
time's expired,
anymore.
Mr. Connolly's time's expired.
I'm sorry
Mr. Connolly's time is expired. Mr. Connolly's time is expired. Order.
I was trying to reclaim the time the gentlelady stole from me.
Oh, we stopped the clock. I watched it. I'm paying close attention. I do feel compelled to respond to this. We have engaged in good faith negotiations. We've offered every witness a narrow scope of topics, documents in advance. They can choose the date. Hunter Biden's lawyer has not engaged with the committee regarding Hunter Biden. Chair now recognizes Mr. Waltz.
Did you respond to their letters to offer to cooperate, sir?
Mr.
Mr. Chairman, did you respond to the lawyer's offer to cooperate with the committee and meet with the committee?
Do what? Yeah, Chair recognizes Mr. Waltz for 5 minutes.
Thank you, Mr. Chairman. This is an incredible
first hearing with this committee.
Welcome to the Oversight Committee.
It was, but you know, I mean, this was entirely predictable. I think what we were going to hear and see today. We saw that Hunter came and staged a PR stunt with my friend from Florida, Mr. Moskowitz. That was clearly organized and recognized. But what I'm hearing from the ranking member and his colleagues that claim that transcripts are subject to, quote, partisan and twisted leaks and distortions is incredibly rich. Let's talk about calling the kettle black first. The country suffered through an entire impeachment proceeding of a president of the United States because of a false dossier in a SCIF, a compartmented facility where every hearing and every transcript started with, this is an unclassified proceeding, then to have it selectively leaked and lied to the American people, to the great damage to this nation, but then bring it to this committee because I'm new. I watched yesterday as committee Democrats continued to spin false narratives, several of which went out just yesterday as interviews were ongoing with Hunter Biden's art dealer, which is rich in and of itself, that Congressman Golden on the other side of the aisle went to the press during the interviews and spun a narrative while it was going on, but he conveniently omitted that 70% of the art buyers were Biden donors. So we can go down the line and talk about
false,
spin.
sir. That's not the facts.
But the other thing that we're hearing today, well, member so-and-so, Congressman so-and-so, Congressman Jordan, they didn't comply with their subpoenas. But let's have a quick lesson on the Constitution. Article 1, Section 6 of the Constitution, the Speech and Debate Clause, essentially protects all of us from abiding by each other's subpoenas. Otherwise, this body would do nothing but subpoena each other. So I would encourage my colleagues to look up Article 1, Section 6 and look at the case law of the Speech and Debate Clause and why my colleagues rightfully did not abide by that subpoenas. But let's talk about precedent for a moment of a president's son abiding by lawful subpoenas of the Congress. Donald Trump Jr. came before this body. He came before the House Intelligence Committee. He came before the House Judiciary Committee. He came before the Senate Intelligence Committee twice. He came before the so-called Jan 6 Committee, all behind closed doors where lawyers can sit down, both sides of the aisle, and have a conversation, go through documents, all under oath, which is the precedent for any committee. Don Jr. came before committees and came before this body 5 times behind closed doors. What is Hunter Biden afraid of? What won't he do? And Ranking Member Raskin, you're going to reap what you sow, my friend. I mean, you insisted on depositions for those who appeared before the Jan 6 committee when Steve Bannon agreed to testify publicly. You argued, sir, that he should have to sit for a closed-door interview, just like every other witness. Quote, the way we have treated every single witness is the same. They come in behind closed doors. They talk to the committee there. You said on an interview in front of CBS in 2022, but now that Republicans are doing the same process, following House rules, doing the investigating, somehow Hunter Biden, because he's a Biden, should be held to a different standard. At the end of the day, we had a government official and the President of the United States, a vice president, set up 30 shell companies. Why? What product did those companies sell? Nothing. Vice President Biden was charged with 2 countries in his portfolio, China and Ukraine. While the vice president, his son, traveled on official business on Air Force 2 and received massive monetary contributions afterwards. We have laws in place, colleagues, that prevent foreign powers from influencing government officials. Were policies changed as a result of the dinners, the calls, the text messages that we know President Biden engaged in through his son? We have a duty to get to the bottom of it. We will reference this contempt. and we will see if the Attorney General will uphold a fair standard of the law
The time's up, Mr. Chairman.
and prosecute Hunter Biden.
Time's
Thank you, Mr.
expired.
Chairman.
Chair now recognizes Ms. Crockett for 5 minutes.
Okay, all right. So we love